Hello, everybody. How you doing? Make sure I am not unmuted here. So, how's everybody doing? We're going to be talking more about the motion here today. I'm going to spend a little more time, and I'm going to really try to take more of your guys' questions more than anything else, really. But we'll kind of go through it a bit. Okay, so. All right. So obviously, you guys may have seen the couple of things I did yesterday. Where I, briefly went through it last night after my premiere. I went live and went through it a bit. So some of you may have seen that over on Millbilly's channel. They went through it pretty extensively. They had Travis on, Big Jeff, and Reality Check. A lot of the folks you guys know. They were over there discussing it. Really interesting discussion over there. So I encourage people to go check that out. So we're going to go ahead and talk about it today. Hi, Dark Side. How you doing? So we're going to go ahead and talk about it today. And like I said, I'll be keen on, talking to you guys and answering questions if I can. So we'll go ahead and wait for some more people to show up before we get started, obviously. That way, less people are like, what happened at the beginning? So, hi, guys. Hey, Mos, Call. Hey, Cat Gamer Girl. So, I'll tell you what I'm pretty excited, though, about, and we'll be talking about it first, is the judicial estoppel. That part is just, I love that. I remember reading about it. She did bring this up in a previous brief when the state had flip-flopped its position. She had originally brought this up then, and I do remember reading about it before when she brought this up. So it was but when it came up at the beginning of this brief in reference to the state's switching of their stance on this, I thought it was brilliant. So it was pretty awesome. So hold on, we're still at 16 people, so I'm just going to wait for some more folks to get here before we get started. Has everybody that's here in the chat, have you read the reply yourself, or at least have you watched some coverage about it? Hey, Linda K. By the way, Linda, I want you and Rhonda tomorrow to go live with Paul and Mitch and I about Daniel Holtzclaw, just so you know. So, as I said, I'm waiting. Okay, we're at 21. I'm just waiting till we get closer to 30, 40, before we start, just because it takes sometimes people a little bit of time to get here. So, and then there's often people that are, what I missed at the beginning. So I want to just go ahead and wait a little bit. You didn't give her a choice. Hi, Kelly. How you doing? Hey, Sherry. So, but yeah, the judicial estoppel is great, right? Because, I mean, what's so great about that is that it's effectively putting a procedural bar on the state. Their argument that Avery's blocked by procedural bar is in contrast to their original position. And so therefore they should be, stopped from being able to make that argument. I hope the Court of Appeals grants that argument, and I hope the state is blocked from arguing procedural bar. That would be awesome. Hello, Bridget. How you doing? So, all right. So yeah, I mean, obviously that one's good. There's a lot of stuff in the brief that's interesting. The other part that I thought was interesting. Oh, T1. Hey, what's up, buddy? Another thing that I thought was interesting, and we'll probably get to it as we're going through here, is the part where they talk about the part where they're flip-flopping essentially on the fact that before they said Stephen's pro se motion was like, I mean, to paraphrase, they were just saying like it was stupid and dumb and ridiculous, right? But now it's like, because they're trying to bar Zellner from being able to bring any of the claims from that motion, basically, They are now arguing that, oh, Stephen did a pretty good job of raising legal issues and everything. It just so happens they had been ruled on previously or whatever, right? It's like, well, that kind of tells you how little he understands the factual basis in the law and really doesn't know what he's doing. I mean, that just basically tells you how inept he is. Anyways, but the fact that the state has flip-flopped, going from he was completely stupid and dumb and his pro se motion was complete garbage to now it was like, oh no, it was very well done and everything. It just so happened that it had already been addressed. You know what I mean? It's like two different points. And I'm wondering if judicial estoppel couldn't apply to that. So, hey, Big Stevish. Oh, thank you, buddy. Much appreciated. Thank you so much. Let's see here. Fighting chemo treatments, but a good day. Oh, I'm sorry to hear that, Bridget Blair. I hope you feel better. I'm glad you're having a good day. Hello, Shaz. Once again, thank you, Big Stevish. Much appreciated. Let's see. They wrote it mockingly towards. Yeah, I agree. Hi, JoJo, Mary. Oh, hey, JoJo. I remember meeting JoJo over at the Duke of Enmore. Very, very sweet lady, folks. Let's see. They may as well just let them out. She spanked them and sent them to bed with no dessert. She did do this very well. I mean, she's basically throwing the state's own BS in its face. At one point in here, which you guys saw me point out last night, where she actually points out how the actual circuit court itself, well, in regard to Stephen's indigence and inability to argue his case properly, she shows how that the court has actually reversed its opinion. Interesting stuff. I mean, she's like, for me, that was like a bitch slap to the circuit court right there. When she pointed out the circuit court's flip flopping on it, it was like bitch slap. See, didn't miss much yet, Moten, because I waited about 5 minutes before I really got going in the last two go rounds, and there's an end in sight. I'm glad to hear that, Bridget. I hope you come out of it, and I hope you feel a lot better. Yeah. I think KZ did. Yeah, so it's interesting. So let me go ahead and pull up the document here for you. So here it is. So obviously this first part is the judicial estoppel argument. The first part of this reply is all about the judicial estoppel. Now, you guys saw me show this part yesterday, basically. But let's go up here and read a bit of the beginning. So the state is stopped from bringing the procedural bar claims. In Wisconsin, the doctrine of judicial estoppel is used to prevent litigants from playing fast and loose with the judicial system by maintaining inconsistent positions during litigation. Salveson versus Douglas City. Specifically, judicial estoppel precludes a party from asserting a position in a legal proceeding and subsequently asserting an inconsistent position later on in that legal proceeding, right? So that's essentially what the state has done, because originally they weren't opposed to more testing, and Steve and Avery, they were unopposed. They were making agreements with Zellner, as she's going to point out later on in here, and they were unopposed to it. So to now have flip-flopped and to be arguing that Avery is procedurally barred from something that they previously agreed he should be able to test and do all that sort of stuff, it shows that they are switching positions strictly because they feel that argument favors them, better than their previous argument, whatever it is. But it's a flip-flopping of convenience, and that's what judicial estoppel is meant to prevent. And so hopefully that's what's going to happen. Contrary to the state's argument that it does not matter what the parties agreed to, the state's prior agreement with Mr. Avery's counsel utterly disqualifies the state's procedural bar arguments, the focus of the state's brief. The state is stopped from entirely changing its position in arguing that Mr. Avery is procedurally barred from raising his claims after it agreed with Mr. Avery, or it agreed that Mr. Avery could amend his motion, conduct additional scientific testing, and if needed, schedule a 4-week evidentiary hearing. Judicial estoppel applies to the parties' positions, not that of the judge. State versus McFarland. So this has nothing to do with Judge Angie's position, is what she's saying. This just has to do with the prosecution of the state's lawyers and her, and where the lawyers stand on this, and it has nothing to do with the judge. Oh, thank you so much, everybody. So a reviewing court determines de novo whether the elements of a judicial estoppel apply to the facts of a case. 3 elements are required for a court to invoke the doctrine of judicial estoppel. Number 1, the latter position must be clearly inconsistent with the earlier position. The facts at issue should be the same in both cases. And 3, the party to be estopped must have convinced the first court to adopt its position. Mr. Avery meets all 3 for the following reasons. Number 1, the state's current position that Mr. Avery is procedurally barred is clearly inconsistent with the state's September 18, 2017 agreement with Mr. Avery that he could amend his petition. The facts at issue are the same before this court and the circuit court. The state, by not objecting to the existence of the agreement described in Mr. Avery's motion to vacate, convinced the circuit court that there was, in fact, an agreement. So there we go. The circuit court itself was convinced that there was an agreement because the state did not oppose it. Did not oppose what Zellner claimed in her motion to vacate. So therefore, even the circuit court assumed that it was true. So that makes it a bit more binding, and so I'm hoping that's going to make it have some teeth and actually end up, working in against the favor of the state. So, Zellner's my new girl crush. Bitch, slap the like button. There you go. Swipe your DNA. Thank you, everybody. Thank you. Hit that like button. The state failed to object to Mr. Avery's motion to vacate. So this is where she basically goes into explaining why, because the state did not object to all the things that she said in her motion to vacate, because they offered no objection, they are basically acquiescing to the fact that it was true. And so it's undeniable now that there was an agreement between Zellner and the state. And so now that's what's hopefully going to make this argument have teeth and bite, because if the state didn't object when Zellner said they had an agreement, and even the circuit court interpreted it that way, then it's just not, it's disingenuous that they are now saying that Avery's procedurally barred from doing things that they originally agreed he could do. So, so that's basically what that comes down to. The fact that they didn't object. So, this is from her prior motion, talking about how on October 6th, defense counsel spoke to the prosecutors and informed them that this motion would be filed today to vacate the order, blah, 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 blah. So, all right. When current post-conviction counsel asked whether the circuit court should immediately be informed of the agreement, Prosecutor Fallon stated that once he had finalized the scheduling of the RAV4 examination with law enforcement, a stipulated order could be presented to the circuit court, similar to the original stipulated order for independent testing. So, yeah, and what this is all basically coming down to is that there, because, and this is the difficult thing, it's like Zellner's trying to work with the state and trying to, do this all above board and everything. But when Fallon said, well, we need to get these things moved over here and that sort of stuff, and tells her, well, we'll file it when we get some of the logistics worked out. I mean, I guess she was supposed to file something, and I guess she should have. Had she filed something prior, to Judge Angie making her decision regarding the original motion for post-conviction relief, this might have all been different. So but you got to wonder at some of the games that are being played here by the state. You know what I mean? So, stipulated order was presented, could be presented to the circuit court, similar to the original stipulated order for the independent scientific testing entered on November 23rd of 2016. Mr. Avery relied upon the agreement with the state and the state's request for additional time to schedule the testing of the RAV4. By not objecting to Mr. Avery's motion to vacate, the state has waived this argument on appeal. The state should be stopped from changing its position now. So, all right. Let's move on to section 2, because I think we all got it, how the judicial estoppel works. So let me take a look at the comment section here real quick. I like how KZ adds in some nods to the MAM community in her replies. Shows she is listening and aware of what's happening in the armchair research sleuth fund. Yeah, I'm sure she has some awareness of what we're all picking up. That's funny. I love it. Yes, acquiesce. Yes. It's kind of a sexy word, isn't it? You know? I don't know. Anyway. Anyways, moving on. So, yeah, I hope they are stopped. So, anyways, the state's erroneous application of the fundamental principles of post-conviction review. The state argues Mr. Avery must affirmatively allege that his facts were sufficiently pled, which is not the actual standard. The proper standard is from State versus Allen, which Mr. Avery satisfied in his brief, even presenting a chart for greater clarity. Let's see. The standard governing a petitioner's right to an evidentiary hearing. The state argues 13 times that Mr. Avery failed to prove his facts and disprove the state's case. But in the state's, let's see. Conceding that an evidentiary hearing is a forum to prove factually supported claims. The standard is that the facts must be assumed to be true in determining whether or not to grant an evidentiary hearing. That's State versus Bentley. The state fails to assume Mr. Avery's facts are true as the standard requires. The state reverts to a sufficiently proven standard, which does not exist. Mr. Avery is not required to prove the facts supporting his claims before the court. Oh, it's freaking hilarious. A sufficiently proven standard, which does not exist. Anyway, so yeah, hilarious, right? The state's brief inadvertently concedes the need for a hearing by creating numerous factual disputes and arguing and weighing the evidence. See factual dispute chart infra. So that's at the end of this, folks. You guys might have seen that last night during Millbillies. I'll try to go through that chart here today. Ironically, the state uses the term conclusory 25 times in a conclusory fashion to describe Mr. Avery's arguments without explaining what is conclusory about them. A post-conviction movement need only provide sufficient objective factual assertions to be entitled to an evidentiary hearing. That is, a movement need not demonstrate theories of admissibility for every factual assertion he or she seeks to introduce, which basically means it's assumed that the facts are true, and then it goes to an evidentiary hearing to test that further. Mr. Avery's claims are not procedurally barred. Mr. Avery is not procedurally barred by his 2013 pro se 97406 motion. The state argues Mr. Avery failed to show sufficient reasons for the not raising his June 2017 claims in his 2013 pro se motion, arguing that Mr. Avery's indigence and lack of legal training were not sufficient reasons. The state's brief claims Avery's assertion that he was incapable of recognizing and raising legal claims was demonstrably false. The circuit court remarked that Avery's pro se motion recognized significant legal issues which the court previously ruled on. However, the circuit court's recent opinion is disingenuous because the circuit court previously ruled that Mr. Avery's claims in his pro se motion were unsubstantiated, empty and without substance, completely meritless, bordering on frivolous, and wildly speculative. That's what the circuit court previously said about Stephen Avery's pro se motion. Okay, and now they're trying to claim that Avery's pro se motion recognized significant legal issues which the court previously ruled on. Baloney. Oh, Lord. Anyways, okay. Miraculously, the state has transformed Mr. Avery into a legal scholar to serve its own purposes. Jeez. Let's see here. Take a look at the comments. Double use of conclusory. Yeah. There's the mockery I was mentioning. Yeah. So, Mr. Avery has demonstrated sufficient reason throughout his brief and supporting affidavits. Affidavits are considered part of the pleading. The Wisconsin Supreme Court found that an affidavit was not insufficient to make a valid claim for newly discovered evidence, reasoning that a movement need not demonstrate the admissibility of the facts asserted in the post-conviction motion, but rather must show sufficient objective material factual assertions that, if true, would warrant the movement to relief. The state misinterprets Mr. Avery's argument to conclude that Mr. Avery's claims were available to him since 2013. In 2013, Mr. Avery lacked legal knowledge, had cognitive deficiencies, and had no way of knowing the factual and legal basis of the claims in the instant appeal. Mr. Avery's 2013 pro se motion demonstrates this, as none of his 11 issues were meritorious or could have possibly raised the subsequently discovered Brady, Youngblood, and new evidence or ineffective assistance of counsel arguments. He had no way of acquiring knowledge of the factual or legal basis for his current claims. So basically, there's no way Avery himself, sitting in prison, could have done the necessary things to bring his current claims. And you're going to see that one of those things is Avery tried to get experts. Nobody wanted to deal with him. The only way he got experts is when Kathleen Zellner got involved, and the experts were willing to come in and do it for Kathleen Zellner. So the state concedes that Mr. Avery's pursuit of his pro se petition was diligent, but he failed despite his diligence. The fact Mr. Avery in 2013 was diligent despite the unavailability of the necessary information supports his position. It means that Avery's been, that it's like the state is admitting that Avery has been diligent. He's been ineffective, but he's been diligent. So it's not like he's been sitting on his butt doing nothing and not looking to develop the evidence to help free him. So the fact that the state has essentially conceded to the fact that Stephen has been diligent doesn't work in the state's favor, which is another interesting thing. So, where the Supreme Court found that the habeas petitioner was entitled to an evidentiary hearing on a juror bias claim since he was diligent in his efforts to develop the facts. Because Williams was not on notice of the juror bias issue, the Supreme Court found that Williams did not fail in his duty of due diligence. The Supreme Court held that unless there is a lack of diligence or some greater fault attributable to the prisoner or the prisoner's counsel, a failure to develop the factual basis of a claim is not established. So basically, you can't blame the person who's been convicted for not finding it if they've been diligent and looking, but it just was not possible for them sitting in a prison to be able to do what was necessary, is essentially what that's getting at. Applying Williams, Mr. Avery did not fail to assert claims of which he had no notice. Further, as in Williams, Mr. Avery's claims were unavailable to him even if he did have legal knowledge, because they are based on evidence withheld by Brady and Youngblood violations, discoverable by only expert examination and not pursued or recognized by his prior attorneys, which goes into the ineffective assistance of counsel. Because Mr. Avery is a learning disabled indigent prisoner, he simply could not have been aware of the factual. Oops, sorry, folks. That's my premiere for Daniel Holtzclaw for tomorrow. Finishing up. Anyway, sorry. He could not have been aware of the factual basis of his claims. The Wisconsin Supreme Court has also found sufficient reason where the movement lacked factual awareness of the claim. State versus Allen. Even if Mr. Avery knew he needed experts, he could not persuade any experts to assist him. Therefore, he could not have known that the blood had been selectively planted in the RAV4. The bullet fragment FL had wood, not bone, embedded in it. The hood latch swab never touched the hood latch. Miss Hallbach's subkey could not have fallen out of the bookcase, and the subsequent discovery of numerous Brady and Youngblood violations. Mr. Avery wrote to dozens of attorneys, all of whom rejected his requests, including Kathleen Zellner for some time, after his direct appeal was denied. Mr. Avery also wrote to laboratories that would not respond unless he had an attorney. Mr. Avery described the impossibility of his efforts to get experts due to his pro se status, not lack of awareness that he needed them. The circuit court should have granted an evidentiary hearing on Mr. Avery's allegation that he lacked the factual basis in 2013 to make the current claims. It's absolutely true. There's no way Stephen could have brought these new claims himself back in 2013. That is absolutely true. All right. Significantly, the state ignored State versus Anderson, which Mr. Avery relied upon in his June 17, 97406 motion. In Anderson, the defendant, like Mr. Avery, argued that his cognitive deficiencies provided a sufficient reason for not raising certain claims prior to his 97406 motion. The court was skeptical of Anderson's claims regarding his disability, but the court assumed Anderson's disabilities excused his failure to raise the claims earlier. Applying Anderson, Mr. Avery is not barred from raising his claims because he raised several sufficient reasons, including his cognitive deficiencies, impossibility of hiring experts, and the lack of factual and legal awareness for explaining why he could not raise his claims in his 2013 motion. Hello, Marilyn. Who all do we have new up in here in the chat? Let's see. Hey, Slayer Rocks. Hey, Henbury, how you doing? Hi, Caperby. All right, looks like I got everybody there. Okay, so the circuit court failed to rule on prior post-conviction counsel's ineffectiveness. The circuit court failed to address prior post-conviction counsel's ineffectiveness because it applied the wrong legal standard. The circuit court stated, the circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, State versus Knight. In this matter, if the defendant wishes to pursue the claims regarding his appellate counsel, the defense may file a Knight motion with the Court of Appeals. Now, see what Judge Angie did there was she assumed, they were talking about post-conviction lawyers, not appellate necessarily lawyers. And so the difference is that when you're in post-conviction lawyer, you're arguing the case post-conviction at the circuit court level. And I believe appellate lawyers are on direct appeal. But the point is that it's all covered under post-conviction counsel and ineffectiveness of post-conviction counsel. And it doesn't. So basically, it doesn't involve appellate counsel. It involves post-conviction counsel. So therefore, this standard doesn't apply. Even the state acknowledges that and says that in their own response that Judge Angie got this wrong. So therefore, by getting this wrong and applying the wrong standard, Judge Angie has effectively not ruled on this. is what Zellner's pointing out, because this is incorrect. It needs to be ruled on properly, So that's what she's saying here. State's answer tried to make out she is not a legal whiz, but someone of Stephen's intelligence. No disrespect to Steve, he isn't a lawyer, but they are answering to one. Makes them look more foolish. Absolutely. So, okay, so Wisconsin law requires a defendant to present a claim of ineffective assistance of post-conviction counsel to the trial court in the first instance. See State Rothering versus McCautry. A Knight petition is only appropriate for claims of ineffective assistance by appellate counsel. Oh, shoot. Because Mr. Avery alleges ineffective assistance of post-conviction counsel, not appellate counsel, the circuit court improperly refused to rule on his claim. So which is basically what I was just saying, right? That the fact that it was improperly ruled on by Judge Angie is effectively, there's been no ruling on this point. And so that effectively means it needs to go back to the circuit court and be corrected, is the way I think that comes off. Or it'll be one of the reasons why it gets sent back for an evidentiary hearing. Specifically ordered evidentiary hearing, you know what I mean? So in State versus Kunze, when faced with a similar legal error by the trial court that resulted in no record for the appellate review, the court held, if the circuit court is able to conduct an adequate retrospective hearing, it shall do so. Therefore, in the instant case, the court must hold an evidentiary hearing about the allegations of prior post-conviction counsel's ineffectiveness. So, there we go. Mr. Avery pled sufficient reasons for failing to raise prior post-conviction counsel's ineffectiveness in his pro se motion. The state argues Mr. Avery fails to establish a sufficient reason for not including his current ineffective assistance of prior post-conviction counsel claim in his pro se direct appeal. Mr. Avery not only alleged a reason, he has demonstrated a sufficient reason consistent with Wisconsin Statute 97406 and State versus Escalona Naranjo. What constitutes a sufficient reason pursuant to Wisconsin Statute 97406 is determined by a case-by-case basis. The Wisconsin Supreme Court has held that ineffective assistance of post-conviction counsel may constitute a sufficient reason. State versus Romero Georgiana. Let's see here. Mr. Avery's pleading alleged sufficient facts for his claim of prior post-conviction counsel's ineffectiveness. Mr. Avery alleged sufficient facts about prior post-conviction counsel's ineffective failure to hire experts. So it's basically getting down to the fact that Dean and Jerry failed to hire experts, and that's why she's making the claim for ineffective assistance of counsel, and missing out on the third-party Denny stuff. Because they didn't hire some of the experts that she hired in order to raise Bobby and Ryan to the level of, Denny suspects. Clearly, prior post-conviction counsel recognized the need for experts on Avery's behalf because they asked the court for an extension to retain experts, stating counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise, just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. So there you have it. I just want to point out, I want to get back to Stephen Avery's indigence here real quick. Here you have Stephen Avery's appellate counsel saying that even they, need scientific experts for matters beyond their knowledge. And yet somehow the state and the circuit court are arguing that Stephen could have somehow done this all on his own. When even we see his own post-conviction counsel saying that they would need experts to help supplement their knowledge in areas beyond their scope, essentially, right? So I just think that's interesting, but moving on. The pivotal question is whether Mr. Avery's 97-406 motion is sufficient to entitle him to an evidentiary hearing, where he would have the opportunity to show that his trial and prior post-conviction attorneys rendered ineffective assistance of counsel. Determining whether counsel's performance was deficient requires the court to focus on counsel's perspective at the time of trial, which means they need to be asking Dean and Jerry questions. The only way to resolve the ineffective assistance of counsel issues means there needs to be an evidentiary hearing, and so that the state and Zellner, everybody can ask them questions and find out what their strategy was, what was in their minds, and so that it could then be determined whether or not it was part of their trial strategy or whether they just dropped the ball in its ineffective assistance of counsel. All right. Determining whether counsel's performance was deficient required. Right, like I said. So let's go ahead and move down here. Okay, let's see here. The circuit court erroneously exercised its discretion in denying Mr. Avery's motion to vacate and motion for reconsideration in contradiction of the 2007 order by Judge Willis. Mr. Avery properly argued that the state's refusal to vacate its judgment violated the 2007 preservation of testing order. She did argue that. I do remember it. I remember. In fact, you know why I remember it? You know why I remember it? Is because I remember at the time when she made the argument that Tracy and Travis felt like it was a kind of a lame argument or a moot kind of argument. Like they didn't really agree with what she was arguing, but it was in there. It was in there. I do remember. And the fact I remember it, I know why I remember it is because I remember Travis and Tracy seemed to have some kind of like, they just didn't, they weren't looking at it favorably. They seemed to have a problem with it. And so it stuck out in my mind. So now when I'm seeing this and I'm remembering that, oh yeah, I do remember this was mentioned, it's like, because the state was, obviously trying to say that had Mr. Avery brought up the fact that the circuit court's order effectively refused, or violated the 2007 preservation testing order, then he might have found success there. Well, it was mentioned, as we're about to see. So the state incorrectly asserts that Mr. Avery failed to raise the argument regarding the circuit court's violation of the 2007 preservation and testing order, claiming this argument appeared in none of Avery's motions to the circuit court. However, it did. In his second amended supplement to his motion for reconsideration, Mr. Avery pled the effect of the court's failure to vacate its October 3rd, 2017 ruling is that it has unilaterally blocked all future scientific testing in the Avery case, in direct contravention to the April 4, 2007 order entered by Judge Willis. So it's there. They've pled it. The state claims they didn't, but they did. So you start to get a little bit more of a feeling of there's some grasping at straws by the state. Even though they seem to, their argument in their response seemed very strong, I think there's some grasping at straws there, and I think Zellner is basically calling them out on all of their flip-flopping and disingenuous kind of behavior. So the state cites Shonshek v. Picard. Shonshek is inapposite, as it is not a post-conviction case, rather a products liability case in which a defendant manufacturer failed to mention even once that the plaintiff violated a Wisconsin statute until his appeal. Mr. Avery's newly discovered evidence in his motion for reconsideration. The state disputes Mr. Avery's evidence is newly discovered, citing that State v. Fosno, to argue that newly discovered evidence does not include the new appreciation of the importance of evidence previously known but not used. In Fosno, the defendant's new diagnosis was merely the new interpretation of existing evidence. Similarly, in Vara, the evidence was newly discovered importance of evidence previously known and not used, where both trial defense counsel and the defendant knew of the defendant's head injury, which could have supported an insanity defense. Both cases are inapposite because Mr. Avery's newly discovered evidence does not consist of already known facts. Rather, post-trial experts revealed facts that were unavailable at trial. In denying Mr. Avery's motion, the Circuit Court erroneously applied the newly discovered evidence standard to mean that the test could not be available at the time of the defendant's previous motion, pursuant to the Wisconsin Statute 97406, or any other appeals or motions filed after trial. The Circuit Court believed that the new evidence could not have existed before 2017. That is not the standard. When moving for a new trial based on newly discovered evidence, a defendant must prove: number one, the evidence was discovered after conviction. 2, the defendant was not negligent in seeking the evidence, which we already know the state has acknowledged that Stephen Avery has been diligent. Number 3, the evidence is material to an issue in the case. And number 4, the evidence is not merely cumulative. Okay. If the defendant can prove all 4 of these criteria, then it must be determined whether a reasonable probability exists that had the jury heard the evidence, it would have had a reasonable doubt as to the defendant's guilt. Here, Mr. Avery presented the following new evidence. Dr. Christopher Palahniuk, using the 2016 state-of-the-art microscope, examined item FL and the hood latch swab, and his findings have produced new evidence that is totally inconsistent with the state's theory that Ms. Hallbach was shot in the head while lying on Mr. Avery's garage floor, and that the hood latch swab was actually used to swab the hood latch. John DeHaan, a forensic fire expert, determined that no body was ever burned in Mr. Avery's burn pit, based upon the data he collected from his experts burning human cadavers since 2012. Dr. Carl Reich was able to, through the use of new source testing, RSID testing, developed after the trial to eliminate blood, semen, and saliva as the sources of DNA from the hood latch swab, leaving skin cells, right? And offered the opinion that the DNA was consistent with what you would have found on Mr. Avery's groin swab from his skin cells. The state mischaracterizes Mr. Avery's argument regarding trial defense counsel's ineffectiveness. Oh, wait. I love this one here. I love it. That's a great one right there. That's a good one. All right, so the state mischaracterizes Avery's argument regarding trial defense counsel's. Okay, the state stating, in a nutshell, Avery argued in his June 2017 motion that string and buting were ineffective because Avery believes he could have prevailed at trial if string and buting had presented his planted evidence defense in the manner current post-conviction counsel formulated. Mr. Avery never argued that trial defense counsel were ineffective for failing to present his planted evidence defense. Instead, Mr. Avery argues that they were ineffective for failing to hire experts, failing to investigate and impeach Bobby Dassey, failing to establish third-party suspects, and failing in numerous other ways. Where trial counsel was ineffective for failing to hire a competent expert to bolster his trial defense, that the defendant was misidentified as the killer. The state cites Lee versus State for the proposition that permitting post-conviction counsel to argue a different game plan after the contest is over would be Monday morning quarterbacking. However, Lee is distinguishable. Lee's defense was available at the time of trial, but his counsel merely chose not to pursue it. Conversely, Mr. Avery is not arguing that his counsel could have chosen a different defense out of those available. Rather, he argues his counsel for ineffective for failing to hire the experts to investigate. The state again mistakes Mr. Avery's argument by claiming that Mr. Avery is contending that trial defense counsel should have hired his specific current experts when Mr. Avery actually argues that trial defense counsel was ineffective for failing to hire experts in those specific areas of expertise: blood spatter, DNA, trace ballistics, police procedure, forensic fire, and anthropology with Kerf mark specialization. Mr. Avery never argued that trial defense counsel should have hired his specific experts. Instead, Mr. Avery argues that trial defense counsel was ineffective for failing to hire experts at all. Besides this, the state grossly mischaracterizes Mr. Avery's ineffective assistance of counsel argument as being that the quantity testing results were both newly discovered evidence and that Strang and Buting were ineffective for failing to present them. The newly discovered evidence supports Mr. Avery's argument that the trial defense counsel failed to present an expert to establish that law enforcement planted Mr. Avery's DNA on the subkey. The reason trial defense counsel did not discover this evidence was their failure to hire experts, which trial defense counsel admits. Thus, the state cannot, even by mistaking Mr. Avery's whole argument, rebut trial defense counsel's ineffectiveness. Mr. Avery's Brady and Youngblood claims are not barred because they were raised in supplemental motions. The state claims that Mr. Avery's motions are successive. However, per the appellate court's orders, Mr. Avery's motions are supplemental motions. The law of the case doctrine is a long-standing rule that a decision on a legal issue by an appellate court establishes the law of the case, which must be followed in all subsequent proceedings in the trial court or later on appeal. Even so, the state accuses Mr. Avery of filing in a piecemeal fashion. Filing under the same case number is by nature not piecemeal litigation. Let's see here. Supreme Court recently held that Rule 59E, motion to alter or amend a habeas court's judgment, is not a second or successive habeas petition, but rather part of the first full petition. Mr. Avery's motions and supplements were all filed under the same case number and are simply a continuation of the same proceeding. See Gonzalez v. Crosby. Issue preclusion doctrines are inappropriate where the record reflects that the petitioner is diligently pursuing his claims and supporting facts in his first meaningful post-conviction review. Holding that abuse of the writ doctrines have no application in a first habeas corpus proceeding, and Williams, holding that a prisoner who acts diligently to pursue his claims has not failed to preserve his right to a hearing on his claims. TTM fangirl. From what I understand, she didn't use all the words that she had. Basically, she had words left over. She didn't go to the absolute limit of the word limit. So Mr. Avery has sufficiently pled his Youngblood claim. Even though it is undisputed that the state violated the notice requirement of Wisconsin Statute 968.205 on evidence preservation, the state claims that Mr. Avery cannot prove its bad faith and thus makes an insufficient claim under Youngblood. The argument that Mr. Avery alleges a statutory claim overlooks that Mr. Avery only uses the violation of the statute to show that the state's bad faith is breaching its own duty of notice. A prosecutor has a duty to preserve potentially useful evidence for trial. Arizona v. Youngblood, California versus Trombetta. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in State v. Parker. The state claims that Parker should be overturned after a quick read. However, Parker has been followed and affirmed by numerous decisions and is void of any negative analysis. Therefore, the state's argument is devoid of any rationale for overturning this court's prior decision. No, she got her extended word limit. She used it. She just came up. I think I heard it was something like 30 words under the limit or something. She's just under it. It's not like she did use some of the extra words she asked for, I guess is what I'm trying to say. The bone fragments recovered in the gravel pit constitute apparent or potential exculpatory evidence. The state misconstrues the apparent or potential exculpatory nature of the Manitowoc County gravel pit bone fragments. Mr. Avery presented the affidavit of Dr. DeHaan that Ms. Halbach did not burn in Mr. Avery's burn pit, and her bones were planted there. Dr. DeHaan opined that Ms. Halbach was burned in a burn barrel, and it is undisputed that larger human bones were found in the Dassey burn barrel. A human scapula, portions of a spinal column, metacarpals, and long bone fragments. The Dassey burn barrel bones had cut marks. The gravel pit bones had cut marks. By destroying the gravel pit bones, the state prevented Dr. Symes, Mr. Avery's expert, from matching the cut marks between the burn barrel and the gravel pit, thereby establishing that the Dassey burn barrel was the primary burn site. This evidence would establish a direct connection between the Dassey burn barrel, the mutilation of Ms. Halbach, and the subsequent planting of bones in Mr. Avery's burn pit. Clearly, the killer performed all of these tasks. Dr. DeHaan ruled out tires as an accelerant. Dr. Eisenberg claimed she detected the odor of a flammable liquid and not burned rubber from the bones in the Dassey burn barrel, which the state claimed was the accelerant used by Mr. Avery. Mr. Avery was deprived of the opportunity to link the gravel pit bones accelerant to the Dassey burn barrel bones. The evidence against Bobby of motive and opportunity is apparent. Additionally, if the gravel pit and Dassey burn barrel bones had been linked, the state's star witness would be converted into the primary suspect, precisely, which is why they did not want Dean and Jerry to get their hands on the CD, because if Dean and Jerry got the CD, they would find out very quickly what was going on with Bobby, and Bobby would have been taken away as their star witness and would have become a prime suspect. It's absolutely what would have happened. It's why the issue of Bobby and the dishonest statements he makes on the stand are so important. Dr. DeHaan opines that the bones in Mr. Avery's burn pit were planted after being burned in a burn barrel. Dr. DeHaan stated the discovery of larger fragments outside of the margins of Avery's burn pit and the finding of human bone fragments with similar degrees of fire damage in numerous areas is also consistent with the dumping of burn remains into an alleged burn pit, with some rolling or landing outside of that burn pit. If Mr. Avery establishes in an evidentiary hearing that the primary burn site was the Dassey burn barrel and the bones from that barrel were planted in Mr. Avery's burn pit, that evidence would be potentially exculpatory and would undermine confidence in his verdict. Mr. Avery has established that the state acted in bad faith. Bad faith can be shown by proof of an official animus or a conscious effort to suppress exculpatory evidence. See Yimerson versus Payne. Further, under certain circumstances, it is permissible to draw an adverse inference. It is permissible to draw an adverse inference against the government when it destroys evidence. Vacated on other grounds. Bad faith can also be inferred from the fact that the prosecutor deliberately misled the jury into believing that there was no possibility of human bones in the quarry. In Jimerson v. Payne, the Eighth Circuit held that the defendant established a Youngblood violation regarding a recording that was either lost or destroyed. The Eighth Circuit acknowledged without the recording, we cannot ascertain its significance. However, the fact that it existed and the state failed to disclose it demonstrated a conscious effort to suppress evidence. The reasoning in Yimerson should be applied to Mr. Avery's case to find that the bad faith element has been satisfied because the prosecutor deliberately failed to preserve the relevant evidence. Because Mr. Avery's factual allegations must be assumed as true, he is entitled to an evidentiary hearing. Mr. Avery's motion for relief was filed pursuant to Wisconsin Statute 97406, which requires a hearing unless the motion and the files in the records of the action conclusively show that the person is entitled to no relief. Wisconsin Statute 97406. The statute requires that the circuit court hold an evidentiary hearing when the movement states sufficient material facts that, if true, would entitle the defendant to relief. State versus Allen. In making this determination, the court must assume that the facts alleged are true. Because the circuit court did not hold an evidentiary hearing on Zellner's motion, we will assume that the factual allegations in her motion are true. Even if the facts assumed to be true seem questionable in their believability, the circuit court must hold a hearing. State versus Leitner. Further factual disputes may only be resolved at an evidentiary hearing. State versus Hampton. The following chart illustrates the facts that must be assumed as true for Mr. Avery and the factual disputes raised by the state which necessitate an evidentiary hearing. Okay, so the Ramlow affidavit about the RAV4 being planted. Okay, so the Ramlow affidavit is true, and Mr. Ramlow saw the RAV4 on November 4th, 2005, illustrating that it was planted, and the state's theory that the RAV4 never left the Avery property is demonstrably false. Ramlow's affidavit impeaches Sergeant Colburn's testimony that he was not looking at the RAV4 when he made the dispatch call regarding the vehicle's license plate. Because trial defense counsel did not have a police report documenting Sergeant Colburn's conversation with Mr. Ramlow, they could not impeach Sergeant Colburn. The chronology of the 30 tracks of the MCSD calls to dispatch shows that Sergeant Colburn's call was made on November 4th, 2005. So the state disputing this says Ramlow seeing a similar car somewhere fails to establish any fact about the RAV4 being planted. So this is what needs to be ironed out in an evidentiary hearing. That's essentially what KZ is saying here. By pointing out this chart, she's going, look, this is what Kevin Ramlow says. Here's what the state says. This is what needs to be ironed out in an evidentiary hearing. Let's see, we got more here. The photograph of the poster seen by Ramlow at the gas station included a photograph of Hallbach's car. Let's see. Assuming Ramlow's contentions are true, Ramlow never even knew what Miss Hallbach's car actually looked like because he never saw a picture. He never saw a picture on the missing poster that he says he saw. So, yeah, this is why an evidentiary hearing needs to happen. So, let's see. The Redant affidavit, RAV4 planted. The Redant affidavit is true. The Department of Justice agents knew that the RAV4 was planted on the Avery property. What the state ends up arguing about this is Avery does not say who Redant had this conversation with, when it occurred, what the context was, what the person's belief was based on, or why Redant did not tell trial counsel or anyone else about it in the 12 years between trial and his affidavit. So that's basically all the reasons why there needs to be an evidentiary hearing. That's exactly what the state's pointing out. Of exactly all the reasons why an evidentiary hearing needs to happen. Mr. Redant's affidavit contradicts the state's representation to the jury that the Avery property was inaccessible from the Redant pit. There was a 20-foot berm separating Avery's trailer from access to the rest of the salvage yard. I don't think so. And the Redant pit. Flyover video. The flyover video was deliberately edited to conceal that the RAV4 was not present on the Avery property on November 4th of 2005. On November 4th of 2005, Wendy Baldwin and CCSD Sheriff Poggle conducted a flyover searching for the RAV4. They were in the air for around 4 hours, yet produced only 3 minutes of flyover footage. Prosecutor Kratz made a material admission when he told the jury that the RAV4 was not visible in the flyover video. A credibility determination must be made of the Kratz statement that the vehicle was not present. So that's basically, again, why we need an evidentiary hearing is to iron these things out and see what's what. Avery's claim that the flyover video was edited was utterly devoid of facts and relied wholly on Avery's speculation that more footage must have existed because the prosecutor said the RAV4 was not visible on the video, and the flyover produced only 3 minutes of footage. So the zipper answering machine message CD that disappeared. Zipper voicemail was concealed because it demonstrated that Miss Halbach's final stop was Zipper's, not the Avery's. The contents of the Zipper voicemail may have contradicted the timeline established by the state that Miss Halbach's last stop was Avery Salvage Yard. The state says nothing about Halbach leaving a voicemail at 2:12 p.m. stating that she can't find the Zipper house, but then later arriving at 3 p.m. does anything to contradict the timeline established by the state. So there we go. The state's arguing that it makes no difference. Halbach at the Avery property approximately at 2:30. Okay. Heidel's affidavit. Miss Halbach's day planner was in the RAV4 on 10/31, and then in the possession of Ryan Hillegas. Ryan Hillegas is established as a third-party Denny suspect because he was in possession of Miss Halbach's day planner. There is no proof that this was Miss Halbach's day planner. There is no proof that this was Miss Halbach's day planner. Are you kidding? Did they really say that? Did they really? I'm going to go back now. Page 86 in the state's brief. Okay. Let me write that down. Hold on, folks. I'm going to write that down because I am going to go check that now. I can't believe they actually said that. The Detective Veely CD. All right, am I missing any questions over here? Wait, let me just take a look at the chat here real quick. Hello, everybody. Jury may have been swayed. This is the fourth time I've heard this, and it gets more obvious every time. Detective Veely CD. The Detective Veely CD contained new material evidence that had been previously concealed from prior counsel. The forensic findings and opinions of Detective Veely were entirely contained on the CD in his final report and not on the 7 DVDs. The CD contained recovered pornography. The 7 DVDs did not contain the results of Detective Veely's unique search terms found exclusively in the CD. Those search results were as follows, where it talks about a bunch of the search terms and how many of them came up. Avery does not point to items of evidence he did not have that were on the Veely CD, but not the hard drive. He just complains that he could not have guessed what the search terms Veely used during his examination. So, like I said, this all needs to get argued in court properly and determined properly. Let's see. Impeachment of Bobby Dassey's trial testimony. Bobby committed perjury at Mr. Avery's trial when he testified that he never saw Miss Halbach leave the Avery property. The CD is exculpatory material evidence that has been directly relevant to the credibility of Bobby and would have allowed trial defense counsel to allege Bobby committed the crime. And the state's failure to disclose it violated Mr. Avery's due process right to a fair trial. Only Bobby had access to the computer during the day and the weekdays when the violent pornography searches were conducted. Bobby's trial testimony that he was asleep from 6:30 a.m. to 2:30 p.m. was contradicted by current post-conviction counsel's expert, Mr. Hunt, who found that Bobby accessed the computer 6 times during that time frame. The state. Avery fails to explain why a single statement from Brian to the police that Bobby saw Halbach leave the property would have tipped the scales when the wealth of other evidence pointed at Avery, and when the jury already heard multiple other accounts that conflicted with Bobby Dassey's testimony. That basically does not at all take into account any of the crap that has been, discovered since MAM. I mean, you guys have a shaky case. I mean, that's like denying that they have a bogus case. But anyways, that's what else do I expect from them? The fact that someone views violent pornography does not diminish their credibility as a witness, as Avery claims. Through distasteful though distasteful, it has nothing to do with their truthfulness. Nor would viewing violent pornography refute anything about Bobby's claim that he never saw Miss Halbach leave. Yeah, but that completely ignores the fact that he says he was sleeping, but he wasn't. So why is he trying to convince you that he was sleeping when he wasn't? That's the question. And the state just misses that. And that's why an evidentiary hearing needs to take place. I feel like I'm a broken record saying that. Factual disputes regarding ineffective assistance of counsel. Blood spatter expert Stuart James. The blood spatter in the RAV4 was selectively planted and did not come from an actively bleeding finger. I agree. But James' expert experiments simply assume a number of variables James cannot account for, such as how deep Avery's open cut was, how much a partially healed cut would have bled, how he moved about the RAV4, and the many other ways blood flakes could end up somewhere. Blood flakes couldn't have ended up anywhere. Blood doesn't flake. And the many other ways. Yeah. Anyways. Bullet fragment FL. Bullet fragment never passed through Ms. Halbach's skull, as the state's expert opined. The state's forensic pathologist, Dr. Jensen, testified that Ms. Halbach's cause of death was the result of one or two gunshots to her head. Dr. Jensen testifies that Ms. Halbach's DNA got on FL when it traveled through her brain, causing her death. Dr. Eisenberg testified that there was no evidence of other gunshot wounds to the bones of the parts of Ms. Halbach's body. But so here's what the state says. But contrary to what Avery claims, no one ever said that FK and FL were the two bullets fired into Ms. Halbach's skull. Avery made that inferential leap on his own. No. Your own expert at trial claimed that the bullet had brain matter on it. No, yeah, the state. See, this is why an evidentiary hearing needs to happen. This right here. The state's disingenuous argument right here is bull. Groin swab planted. Groin swab was substituted for the hood latch swab by Investigator Wiegert. Investigator Wiegert hand printed Deputy Hawkins' name on the form, again deliberately misidentifying Deputy Hawkins as the submitting officer, which was a complete misrepresentation. The state fails to acknowledge the significance of Investigator Wiegert signing Deputy Hawkins' name on the WSCL form when he delivered the alleged hood latch swab. Avery based this scenario entirely on the failure of a nurse, of the nurse to note on her report that a groin swab had been taken but discarded, which, according to him, a well-qualified nurse would have done. And the fact that Wiegert and Fassbender instructed Deputy Hawkins and Sergeant Tyson to swab the hood latch, battery cables, and interior and exterior door handles, but did not include the interior hood release lever and hood prop. Anyway, ridiculous and stupid argument. Hillegas evidence: the trial defense counsel was ineffective in failing to investigate Hillegas as a third-party Denny suspect. Avery provided nothing establishing that the abusive relationship Halbach supposedly was with Hillegas. That Hillegas knew about Halbach's sexual history with Blodorn, and that even if Hillegas did know about it, that he cared. Avery just proclaimed with no evidence whatsoever that Hillegas committed perjury about it. He should have certainly been asked about these things. I mean, anyway. It must be assumed that Hillegas was in possession of Miss Halbach's day planner. I agree. There is no proof that it was Miss Halbach's day planner. There it is again. I really am going to have to go find that one. There's no proof it was her day planner. Are you kidding me? Sub-key planted location. Bookcase experiment demonstrates that the state's trial theory about the discovery of Miss Halbach's key in Mr. Avery's bedroom was false. Importantly, the experiment key and lanyard were able to be pushed through the back of his experimental bookcase by striking it with a photo album. Yeah, but Andy says it was from twisting and shout. He was doing twist and shout with the bookcase. Remember? And that's when it came out. But none of the change on top moved. That's the tricky thing. So anyway. The subkey was planted in Mr. Avery's bedroom, as evidenced by the bookcase experiment and DNA quantities. Dr. Reich opines that the DNA found on the Toyota subkey found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Avery deposited 10 times less DNA on the exemplar subkey than what was discovered by the WSCL and used to convict Mr. Avery. So basically, when they had Stephen hold a key, it ended up having 10 times less DNA than what was found on Teresa's key, which came out of his bedroom dresser cabinet. What Mr. Avery glossed over was that he undeniably left his DNA on the exemplar key during his experiment. But not that much. Not as much as that. And that should matter. State's arguments are just stupid. Dr. Reich opines that the DNA found on the Toyota subkey found in Mr. Avery's bedroom was planted. Dr. Reich conducted experiments which demonstrated that Mr. Okay. Second, like his hoodlatch experiment, Avery's experiment holding an exemplar key bolsters rather than weakens the state's case. I disagree. Electronic devices planted. Current post-conviction counsel's investigator conducted a series of experiments refuting Mr. Fabian's trial testimony that on October 31st, 2005, he was in the vicinity of Mr. Avery's burn barrel and smelled the distinct odor of burning plastic coming from Mr. Avery's burn barrel. Avery's experiment could not account for environmental conditions on October 31st, 2005, any sensitivities of Mr. Fabian's, or the fact that Avery clearly put other items in the barrel as well. Youngblood violations, destruction of bones. The circuit court erred in concluding that the Manitowoc County gravel pit bones were not human, when in fact the Manitowoc quarry bones were labeled as human by Dr. Eisenberg in her reports, describing property tag numbers, all various bones that she had wanted to look at. None of the bone fragments recovered from locations in the quarry were positively identified as human, let alone the remains of Teresa Halbach. That's the whole, but they did have cut marks like the ones that were identified as Teresa Halbach in the burn barrel. So there should have been a comparing of that. So, anyways. It must be assumed that there was a Brady violation when the state failed to disclose the police report. The report in the ledgers, right. The failure to disclose the police report led to the destruction of the gravel pit bones, of which prior post-conviction counsel was unaware. There must be an evidentiary hearing to determine whether prior post-conviction counsel knew of the specific bone fragments that were given to the Halbach family. The state has conceded that there would have been a Brady violation if prior post-conviction counsel did not know about the evidence that was destroyed. Well, they didn't. They have an affidavit from prior post-conviction counsel saying so. So that's why an evidentiary hearing is needed, my friends. Okay. I don't even know if you guys are even listening to me anymore over there. You guys look like you're having a good old time. Anyway, all right, the conclusion. For the reasons stated herein, Stephen Avery respectfully requests that this court grant him one of the following alternative remedies. Number one, reverse the orders denying post-conviction relief and remand for the state to file a response to the motion for post-conviction relief and order additional scientific testing per the September 18, 2017 agreement, and or grant an evidentiary hearing. 2. Reverse the judgments of conviction and the orders denying post-conviction relief and remand for a new trial. Date this 25th day of June 2020. Respectfully submitted by Kathleen Zellner. So, there we are, folks. All right. Yeah. The bookcase experiment says nothing what Colburn says. That doesn't make sense. Absolutely. None of it makes sense. So, am I saying an evidentiary hearing is needed? Yeah, I think that's what I'm saying. I'm saying some fact finding needs to happen. You know what I mean? And I'm suggesting that that some facts haven't been found. Oh, you're all welcome. I was just kidding when I said that, by the way. Let's see. Scott's bondage murder used Bobby as a patsy and alibi. So that's it. That's the entire motion. I know, you guys have probably seen it now a few different times, so, but that's the motion. It's brilliant. I mean, I think she makes a lot of very, very good points. Hopefully the Court of Appeals is going to agree and with the case law and agree with, the what she's arguing, and that we're going to hopefully see some movement on Avery's, case. That's what I'm hoping. So I want to let everybody know that tomorrow I have another Daniel Holtzclaw premiere that I'm going to be premiering around 11 a.m. Pacific time. So that will be about 1 p.m. Central time. And then about 3 p.m. Central time, I'm looking to go live with Linda K, Rhonda South, Mitch from Twitter, and Mr. Capaldi. And we're going to go live after my Holtzclaw premiere, and we're going to be live tomorrow talking about the Daniel Holtzclaw case. So we hope many of you will show up there and give it a look. We'll be here on my channel tomorrow after that premiere. Like I said, hope to see many of you there potentially. What's happened in Oklahoma with the Daniel Holtzclaw case is an absolute farce. This case has almost every single indicator of a wrongful conviction, stupid investigation, just like Wiegert and Fassbender. So many of you who haven't heard of it, please come and tune in tomorrow and check it out and see what you think. Because that's one of the cases that we're starting to talk about now as we continue to create awareness of wrongful convictions, so that the wider world can start to get an understanding of why we need to get involved and why we need to kind of get our justice system in check, because our justice system is kind of dropping the ball in certain ways. So we got to get people aware and understanding what the problems are so that we can get the proper change to happen. So that's another part of it. So wait till you find out about the investigation, Timothy Bryan. The investigation, I'm covering it on my channel. Like I said, I had a premiere today, I had a premiere yesterday, and like I said, part 3 of this particular accuser, part 3 of the coverage of this accuser is tomorrow. And then after that premiere tomorrow, Linda K and Rhonda, Mitch, and Paul and I are going to go live to talk about the Daniel Holtzclaw case. But yeah, once you start learning about what happened in this investigation, you're just going to be like, oh my God, what the, it's just unbelievable what they did, what these investigators did. And they have no remorse about what they did and the unethical tactics that they used. Zero remorse. Zero. All right, folks. So I can tell everybody's starting to say goodbye. So I know, no problem, Timothy. Hey, I'm on my channel covering it. So all you have to do is tune in and watch my Daniel Holtzclaw videos, and you'll get caught up, because I'm using Brian Bates, and Brian Bates is very thorough. He's very thorough, and he makes sure that he puts everything out there so that you can understand all of the things that are going on. So I'm going through it methodically. I'm on accusers 4 and 5 right now. Finishing up with accusers 4 and 5 tomorrow, and then by Sunday or Monday, I will be starting in on it's Carla Johnson, I believe, who will be accuser number 6. So that's what's going on with the Daniel Holtzclaw. Obviously, I'll still be talking about Avery Dassey, Scott Davis, all the various other cases that I do care about. But right now, we are digging into Daniel's case because, well, we feel it's just such a textbook example of a wrongful conviction. I mean, literally, it is a textbook example of a wrongful conviction. What not to do. So I mean, so for those of you, please tune in tomorrow. Like I said, the part three of the part three of the premiere is part three of the series covering accusers 4 and 5, which are Florine Mathis and Tabitha Barnes. And then, like I said, you can go back and watch my previous videos where I cover Sherry Ellis, Terry Morris, and Janie Liggins. And then you can see my original flagship video on the Daniel Holtzclaw case, where I go over basically a summary of what happened in Daniel's case and all the things that went on during the investigation and the prosecution that were fishy. So just go back to my channel, type in Daniel Holtzclaw, and you're going to see some stuff pop up. Go ahead and watch it and get caught up. It's going to be interesting. You'll find it interesting. And like I said, this case is going to be big because, like I said, it's such a textbook example of how investigators and prosecutors go wrong. It's a textbook example. So, all right, folks. I hope you guys enjoyed it. I hope you guys found my coverage of the of Zellner's reply interesting. It's very interesting stuff. I'm hoping that the Court of Appeals is going to be coming back with something in favor of Stephen. It would certainly be good to get finally some good news, for Stephen. Some kind of good news, something to break Stephen's way. I hope we get that. So thank you, everybody, for all your support, for helping me get to 7,000 subscribers. Thank you for all that. Thank you for supporting Avery Dassey. And thank you for taking an interest in caring about wrongful convictions, because as we create more awareness of that, we increase the chances of getting Stephen and Brendan out. And so it's a big part of it. So thank you all for being here and tuning in and learning more about this stuff. If you haven't already, please hit subscribe, and we'll see you.